Good afternoon, everyone. Thank you for logging on and listening to me today. We're going to talk about estate planning for cross-border families. My name is Andrew Talbot from Global Eye. You'll see on the screen my personal website, expatfinancialplanning.com. It's got a little bit more information on the subject, including some of the links that we'll go through today to certain forms and information, as well as news and opinions. It's an extremely complex subject, and I could keep going into really great detail about it. So today we will just try and cover the basics, but your own individual circumstances will dictate how much of the solutions that we present that you'd probably use, and how complex your own personal lives are. So feel free to contact me afterwards, and I can go through the information with you. So really, what are the issues with estate planning for cross-border families? Today's families are complex. We live in an ever-shrinking world, and people in their families reside all over the globe. So there is a need to pass on the wealth to one generation or skip a generation. And having multi-jurisdictions, different currencies, just makes it a little bit more tricky than maybe if you just did it in your home country. So some of the issues are generally forced heirship. Each country might have its might be under a sort of set rules, and forced heirship, certainly in Muslim countries or under Sharia law, where the assets can be passed to family members without necessary towards the deceased's wishes. So there are ways to mitigate this. Next one is probate. You need to go through probate in order to pass assets to the beneficiaries, to the spouse, to the next generation. And there are generally different tax laws, different processes that exist in each of these jurisdictions. So every country will have its own processes, every country will have its own tax laws. And these can have an impact on whether or not you want to pass assets on. And there's also the cost and the time involved in doing this. If your spouse is of a different nationality and they want to access an asset in, say, your home country, then it might be a language barrier. They don't understand dealing with the paperwork or the processes involved. So it just takes a longer time. And sometimes it can take up to 2 years to settle an estate, especially if assets are just unknown or are locked because of certain local rules. And all of this can be provided with proper estate planning. So how would you feel if everything you owned went to someone else's children, or your family members couldn't inherit the family home, or your children were disinherited? And remember that one nation's tax laws may conflict with those of another. So understanding the differences is very important. So where do we start? The first step in estate planning is to calculate the value of the assets and the liabilities. Make a list. All the items that are included in the estate, such as property, shares, investment portfolios, chattels or personal property as we call it, retirement accounts, pensions, all of this should be listed. And then the next stage is to see who owns what. The one spouse member may own a particular property, or the children may own it. So it's understanding really those list of assets and what the local rules are: forced heirship, probate, tax and death and inheritance tax rules that we talked about earlier. It may sound complicated, but it's easier if you start here, and then we can go through each of those different assets and find out what the problems are with each one of them. This is a link to Ernst & Young's Worldwide Estate and Inheritance Tax Guide. What it has is all of not all of them, a number of different countries' rules on inheritance tax, and to a certain extent the local rules that apply to it. So it's quite a good publication to start with. once you've listed all your assets and liabilities. I mean, regardless of the complexity, there's normally two overall goals that we have when you're doing estate planning. First one is to specify how the person wants his estate divided, the wishes of the deceased, and who's going to get what, how quickly and how tax efficiently can they receive it. And the other one is to care for minors until they reach the age of majority. So if you're young parents, then obviously this is an important part of the planning, or the important part to start. We have a number of different tools available that we can use. So there's a will, lasting power of attorney, guardianship, will substitutes, trusts, insurance. There's a few others, but these are the basic ones that we like to start with, and each has its own different complexity. So we'll go through each of these and then some of the outlines, advantages and disadvantages using them, some of the points to consider for your own. But majority of people will at least use one of these tools in order to start their estate planning. The first one is obviously a will, and this really is the starting point of any kind of estate planning. Anyone who has children, property, or other assets, sort of generally over 50k sterling or 75 US, you really should have an up-to-date will telling everyone what you want to happen. Generally, you should have one in each jurisdictions where assets are held. If you have a will, then you can nominate your executors and guardians for young children, make gifts to loved ones, and ensure your wishes are fulfilled. You can also protect property, mitigate inheritance tax, protect the vulnerable or young beneficiaries using stuff like will trusts. So it really is the starting point. But remember, you still have to go through probate on this, and there is a time and a cost associated with it. I mean, disposal of a person's estate after death is governed by the will or by the laws of intestacy if you haven't made a will. So this is where you can end up with some degree of forced heirship. So if a person dies leaving a valid will, then the executors nominated are required to administer the estate, collect any debts, pay any tax, and generally distribute the assets according to what's instructed in the will. If you die without having to make a will, then you have said to died intestate, and the estate's distributed according to the laws of intestacy. So this really is the local rules at that point that will come into it, and that's where sometimes you have the problems. So without a will, you can leave an unnecessary mess. It costs a bit more, and generally the law dictates what happens to the estate. So you end up having no say. So this is really the first point of having a will. And I mentioned earlier about the time and the cost. Now, I'll take a pretty well-known jurisdiction in the UK. The Ministry of Justice have announced a new sliding scale for the probate fee system. Before it was £215, but now, as you can see, you're starting off with estates worth more than 50k. It's going to be 300. But if you go up to 2 million, then you're going to be paying £20,000. So the cost of it has substantially changed. But then also you got to understand that necessarily that if you got a multi-jurisdiction family or a cross-border family, then they have to understand how this process works as well. So it does become a little bit more complicated, and every system will have different rules. It's not exactly going to be the same for each jurisdiction. The next page is lasting power of attorney. The unfortunate results of us all living longer is that we tend to lose the ability to manage our own affairs, whether it's accident, illness, or just old age. And a lasting power of attorney allows you to choose who you'd want to manage your affairs. Without an LPA, as we call it, it can be delays in accessing assets. Costs tend to be a little bit higher, and you don't know who's going to look after those assets or distribute them, but they might not be the same person you want them to. And assets can be frozen as a result because loved ones can't access those assets. So how do you feel if you lost control of your own affairs, or someone else that you don't know is looking after them. You don't necessarily want to become a burden to your family members, so it's worth looking into. The next stage is guardianship. Probably especially important if you've got as for expats or cross-border families, you're in a different country compared to where maybe your parents live or your family support are. So the guardianship is just a temporary legal letter in the case of death of the parents. So for instance, in Singapore, it can be a trusted adult family friend, etc. But what it can't be is a domestic helper, nanny or household employee. So it's worth bearing that in mind. And really it's until a permanent guardian is nominated in your will, usually the grandparents or aunts and uncles come and collect the children. This is a link to the form via my website. Obviously, I'll send this to you if you wish. But most countries under a common law system allow parents to sign a temporary guardianship form. It just provides the authorities with the details of your wishes until the permanent guardians arrive. A couple of points to think on this. Obviously, it's lodged with the guardians or a lawyer or family friends, and it can't be helpers that look after it. If you didn't have this, then it would probably be the local authorities, in this case Singapore, but it would be the same in other countries after them. And then if there's a problem, then here it's the Court of Protection in Singapore, but in other jurisdictions it's likely to be the same similar type legal system. They're unlikely to overrule the temporary guardianship form, but it certainly helps with the processing of it. Just as mentioned, the helper can't be named as a guardianship because she loses a legal right to be in the country after the employee's death. So that's the reason why. Until the permanent guardians come to take the children out of Singapore, etc. And obviously they work in different civil code countries, as mentioned. So the next stage is where we get onto different levels of estate planning. So will substitutes. And generally what we're actually trying to do is remove assets from a will. Although it's the basis of estate planning, we can use will substitutes as another way of doing this. And this is a technique that allows you to transfer property or assets in your death without having to go through the probate process. So you don't have that public and the time and the cost of doing it. So it expedites the distribution process without the costs of probate. As we saw before, it's getting expensive to do. So it's quick, administratively easy to do, and obviously easy to amend. The wishes of the deceased are easily achieved, and it avoids probate and forced heirship. So some of the examples of this could be joint tenancy on a property. So if a husband owns a property, then add the wife. So you have joint ownership. So if somebody owns the husband, then it immediately gets passed to the wife. And you've got no need to have any of the transfer of assets forms or going through probate it's automatically done. So it's very important. Another example is nomination of beneficiaries. So if you've got a life cover, then make sure it's a nomination on there. This could be a trust, but it could also be children, or investment plans, shares, anything that you can add a bank account, so anything you can add a nomination onto there. Should something happen to you, then someone else can access it. It's very easy to do and save a lot of trouble in the future. The next one is trusts. Now, trusts have been around for ages. And there's many different reasons why you'd use a trust, and there's many different trusts. And some countries recognize them, some don't. So it's really depending on what you're trying to do in your own circumstances about how you would use it. The multi-jurisdictions and the different currencies and the different process and local laws really does make it a little bit difficult. But a trust may solve a problem in one particular jurisdiction, but not necessarily solve it in another jurisdiction. They're confidential, they can be tax efficient, and they can provide protection to the family in terms of knowledge, public knowledge, getting around the probate process, as we mentioned before. So if I give you a couple of examples of types of trusts, you can see how many there are. This is just a number of different ones. And it can be set to a particular asset, such as a pension scheme trust or a will trust. Some of them are tax efficient from, say, inheritance tax, such as a bare or absolute trust. But you have no control over those assets once they're being transferred away. So that's one of the disadvantages with it. Where something like a discretionary trust, you can change the underlying assets, you can make trading decisions, but then they're not very tax efficient. So it's really depending on what you are trying to achieve and whether or not a particular trust will help you in that process. They're complex, and you really should take advice on which one to use and how it will impact on your own personal circumstances. The last one really is insurance. Generally, it's whole of life or term, so term set period, such as until retirement, or the children are through university and no longer dependents. Make sure you set it up correctly, as you mentioned, using a trust. But if you use something like a whole of life plan, where it's generally creating a lump sum, you can really leave a legacy. And this can provide for the family, or it can pay maybe the inheritance tax. But certainly if you've got dependent families, insurance really is the first point that you should have, or everyone should have. Definitely if you've got children. But it is really a part of estate planning. So it's another area that, I mean, most people have it, but certainly worth looking into it. And then in summary, first thing, identify the problems. Find out what the local rules are, what the forced heirship, what the tax position is. Start the process. Solve some of the problems by just maybe using a will, maybe using insurance. Doesn't necessarily mean you're going to solve all of the problems. Maybe some of the inheritance tax issues, and then get advice, because it is a complex area, and one area may impact on another. Certainly in terms of country tax laws, you look at some of the big mature tax jurisdictions like Australia, UK, America. They do have worldwide taxes. So the UK is on inheritance taxes, worldwide assets rather than just local. But if you're a Singaporean buying a UK property, then you'll have inheritance tax on those assets. So you can see how not necessarily nationality will make a difference to whether or not you're going to pay tax on these state problems, but it really is the local laws. So it's pretty important just to get some kind of advice. Those are my details. Email, mobile, via my website, or even if you're Twitter, if you're on that, we can obviously help with your own circumstances and find out what one of the best tools or solutions are in able to help you. So thank you very much for joining, and I'll speak to you soon.